Hey folks, I'm Mark Smith, the host of the Four Boxes Diner. For those of you new to this channel, I know there's thousands of you who are new subscribers, and thank you for joining us. I'm a constitutional attorney, a member of the United States Supreme Court Bar. I'm a frequent commentator in the media, including on national TV networks that I'm sure you've seen. And I'm proud to say that in 2021, a federal judge used some of my scholarship to declare California's assault weapon ban as unconstitutional under the Second Amendment. And if you love the Second Amendment and want to protect it, please hit the subscribe button and help us spread the word about the importance of the Second Amendment to America. About a month ago, I gave a very large speech about where the Second Amendment stands in American life today, both in the courts and what are the future fights about the Second Amendment going to be, in my opinion. What is the Supreme Court going to do with it? On and on and on. And I gave this to the Indianapolis Lawyers chapter of the Federalist Society. And I didn't tape it or anything like that, but then I said, this was a pretty good speech. I thought, with a lot of good information, I thought that maybe the viewers on this channel would enjoy hearing it. So I'm basically going to kind of give you the essence of this speech with all the content, because I think, again, it may be a little bit longer, but I think you'll learn a lot from it about the Second Amendment and where we are today. This is a very exciting time to be involved in the Second Amendment, because there's a major Second Amendment case pending before the Supreme Court called NYSRPA, or New York State Rifle and Pistol Association versus Bruen. You see, when the Bruen case was granted certiorari to the Supreme Court, it was incredibly exciting for the entire gun rights community. And this is because we basically have what appears to be, hopefully so, a new composition of the Supreme Court that seems to be far more interested in enforcing the Second Amendment as it was written by our founding fathers. In today's talk, I'm going to do three things, okay? I'm going to mention briefly the last four Supreme Court cases talking about the Second Amendment before the NYSRPA versus Bruen case, okay? Then I'm going to discuss the pending Bruen case, including what I think is the likely outcome of that case before the Supreme Court. And then I'm going to give you a list of what I consider to be the next wave of Second Amendment cases that we can all expect to see after the Supreme Court decides the Bruen case itself. To start, there are four modern day Second Amendment cases decided by the United States Supreme Court in the last few decades that you have to know about. In 2008, we all know that the Supreme Court issued its famous Heller decision in which a handgun ban in the District of Columbia was struck down as violating the Second Amendment's right to keep arms in your home. This was a decision written by the late Justice Antonin Scalia. And in this opinion, the court analyzed the text of the Second Amendment and the Second Amendment's history, all to conclude that the Second Amendment did in fact protect an individual private right to possess firearms, and not some sort of a collective militia right to serve in the National Guard or to serve in the military. No, it's a private right according to the Supreme Court in 2008. Now, 2 years later, in 2010, the Supreme Court, in the case of McDonald versus Chicago, decided that Second Amendment rights of the type they talked about in Heller are fundamental rights that must be incorporated through the 14th Amendment and applied to the states and localities to protect gun owners and people that want to own guns from gun control laws, not just by the federal government, which was Heller, but also by state and local governments, which is the McDonald case. Now, the next Supreme Court case touching on the Second Amendment came a few months after the death of Justice Scalia in 2016. This was a case called Caetano versus Massachusetts. Now, what's interesting is there was no oral argument in the case of Caetano, and the court issued what's known as a per curiam decision, which is kind of interesting. It means the whole court decided it this way. In Caetano, it involved a woman who was allegedly being stalked by her boyfriend, and he confronted her outdoors in a parking lot. And at that time, when he confronted Miss Caetano, she threatened him by waving at him and holding him off with a stun gun. That's a stun gun. Now, at that time, the state of Massachusetts, or the Commonwealth of Massachusetts, banned stun guns. So Miss Caetano was actually convicted of the illegal possession of a stun gun in Massachusetts, in a case that actually had no real, disputed facts. People agreed what the facts were. Now, smartly, Ms. Caetano's attorney argued that the stun gun ban in Massachusetts violated the Second Amendment. It's the right to keep and bear arms. Okay. Now, the Massachusetts Supreme Court, believe it or not, upheld Ms. Caetano's conviction over the Second Amendment argument. And it said that stun guns are not protected arms under the Second Amendment. Specifically, the Massachusetts Supreme Court indicated that because stun guns did not exist at the time of our founding, the court upheld the conviction. Now, this is just totally stupid. In fact, completely disingenuous in my opinion. And thank God, from Ms. Caetano's point of view, that the United States Supreme Court agreed with me on this. You see, the U.S. Supreme Court stepped in and remanded the case back to Massachusetts with a statement and opinion that said that Heller, the decision in Heller, protected arms not in existence at the time of founding, including, of course, stun guns. Now, as a side note, the Caetano case may also be a huge decision down the road involving cases such as AR-15 bans and so-called large capacity magazine ban cases, because those did not exist at the time of the founding, just like stun guns. And that's actually older technology than stun guns. So it'll be very interesting to see how it goes. Now, the other interesting thing about the Caetano case is that the confrontation between Ms. Caetano on the one hand and her ex-boyfriend on the other hand took place in a public place. Okay, this suggests that even back in 2016, when the Caetano case was decided, the court thought that the phrase "to bear arms" included carrying guns in public, which of course is what the NYSRPA versus Bruen case is going to decide. Now, finally, there was this 2020 decision in NYSRPA versus New York City, not to be confused with NYSRPA versus Bruen, but NYSRPA versus New York City, which ultimately was mooted because New York City and New York State coordinated to avoid an adverse ruling under the Second Amendment as they saw it. What's interesting is that the ploy by New York State and New York City actually worked in 2020 because the case was dismissed as moot. So there was no further Second Amendment precedent created. And another opportunity to reaffirm the Heller decision was missed. However, a friend of mine has always told me the following advice. He says, you know what? When God wants to punish you, he goes ahead and grants you your wishes. Well, I think it's very interesting that in the case of NYSRPA versus New York City in 2020, by the anti-gun movement actually dodging a decision in that case, dodging the bullet, pardon the pun, if you will. But that potentially is very good for the gun rights community, because I'm guessing that the NYSRPA versus New York City case would have come out with a very narrow ruling, because the swing vote in that case was Chief Justice John Roberts. But now we may see a much broader Second Amendment ruling, because the swing vote is either Amy Coney Barrett or Judge Kavanaugh, both of whom seem far more favorable to Second Amendment rights than Chief Justice John Roberts has been so far. Now let's turn to the NYSRPA versus Bruen case. Bruen is a case arising from New York State in which the plaintiffs tried to procure concealed carry licenses to carry handguns in New York State for self-defense. Now, their request was denied on the grounds that they failed to show quote-unquote proper cause or quote-unquote good cause to carry in self-defense. You see, New York is what's known as a proper cause or a good cause jurisdiction. Now, this involves concealed carry permits, of course. Now, as you know, in New York State, the open carry of firearms is completely banned in New York. So the only way you can carry a gun in New York State is with a concealed carry permit, because open carry not allowed. Now, I also want to remind you of one thing, that today in over 40 states and the District of Columbia, I want to repeat this, in 40 states and the District of Columbia, a law-abiding American has the right to carry a handgun in public, either without a permit, constitutional carry, or has the right to procure a shall issue permit to carry a firearm. This means that in the vast majority of states in the country, they respect the right to bear or to carry firearms for self-defense outside the home. But of course, New York is one of about 6 states, which includes Hawaii, New Jersey, California, Massachusetts, and Maryland, where you cannot get a permit to carry firearms unless you have a sort of undefined good reason. Of course, again, good reason is really left up to the discretion of government officials reviewing the applicant by the person who wants to carry the gun concealed. But what is generally not considered a good reason, and this is what's kind of shocking, right? What is generally not considered a good reason is that you simply want to carry a gun in self-defense because you're just a law-abiding American, right? A law-abiding citizen who wants to carry a gun for self-defense is a general proposition and is generally not allowed. In other words, I like to call the proper cause standard sometimes the special snowflake clause, where you have to stand out in some unique way or show a special need to qualify for the privilege of carrying a firearm without qualifications. It's not a right, it's a privilege in these anti-gun states, as you know. Hopefully the Supreme Court will fix it. But right now, the First Circuit out of Boston, the Second Circuit out of New York, the Third Circuit out in New Jersey, the Fourth Circuit out in Maryland, and the Ninth Circuit out of California have all upheld these proper cause laws, unfortunately so. But the DC Court of Appeals in a case called Wren versus DC struck these proper cause rules down as unconstitutional. Now this gave rise for those lawyers out there as to what's known as a circuit split that the Supreme Court used to grant cert in the Bruen case we're going to talk about right now. Now let's talk about the legal issues presented in the Bruen case before the Supreme Court. Okay, the Bruen case was briefed, meaning the legal briefs were submitted, and it was argued in early November of 2021. Because it's going to be such a major case involving the Second Amendment, we're unlikely to see a decision in this case until late June of 2022, when they traditionally decide the Supreme Court traditionally decides the biggest cases, announces the biggest cases at the end of the term, which is always the end of June of that year. Okay. So what exactly are the legal issues that the Supreme Court is going to have to resolve in the Bruen case? Well, there's really two main issues in the Bruen case that the Supreme Court's going to have to decide that's very important for our right to keep and bear arms. The first is what's called the standard of review, or the criteria for deciding Second Amendment cases. When does a gun control law violate the Second Amendment? That's a determination of you apply what's called a standard of review or criteria. That's what courts do to figure out, does this gun control law violate the Second Amendment? That's the first thing the court's going to have to decide. The second thing I think the court's going to have to decide is simply this. Does the Second Amendment, the text and the history of the Second Amendment, does it recognize an individual right to carry guns outside of the home in public for self-defense? Okay. First, again, the court's going to have to decide the appropriate standard of review for Second Amendment cases. Now, as I see it, this is going to require the Supreme Court to decide between two analytical frameworks or criteria. The first potential standard of review would be what is called the text, history, and tradition standard that was articulated by the court in the Heller case in 2008. And the other standard of review or criteria would be some form of balancing test, something like intermediate scrutiny, which on this channel I've told you, when you hear balancing tests, when you hear any kind of intermediate scrutiny or tiers of scrutiny, bad. You don't want that. Terrible for gun rights because it just allows judges to basically balance away your right and say the government wins and you lose. You do not want any form of tiers of scrutiny in assessing your Second Amendment rights because it's just going to give judges the excuse to take away your gun rights, and you don't want that ever. Okay. Now, again, intermediate scrutiny allows judges to have the legal authority to balance the interests of gun owners on the one hand, right, who want to exercise their Second Amendment on the one hand, against the asserted public safety benefits, the supposed public safety benefits by the government on the other hand. The balancing test. Balancing tests are bad, but that would be the other criteria. That's what the anti-gunners want the Supreme Court to embrace, a balancing test. We in the pro-gun community want them to embrace a text, history, and tradition test. Okay. Now, it's worth noting that in the Heller decision in 2008, they used the text, history, and tradition of the Second Amendment as the basis for striking down the District of Columbia's ban on handguns in the home. And that decision expressly rejected, in the context of Second Amendment cases, any form of social or public policy balancing tests. And they rejected specifically things like the tiers of scrutiny test in Second Amendment cases. However, since the Heller decision was issued in 2008, most of the lower courts, unfortunately, in the anti-gun blue states, have mostly refused to follow Heller's text and history approach. They assert that the text, history, and tradition test really only applies to so-called core rights under the Second Amendment, which as they see it, because they hate guns, in my view, and they want to just take away your gun rights is what they really want to do, and they're trying to be consistent with Heller. So what they say is that the so-called core of the Second Amendment is very limited. It just says you have a right to a loaded, unlocked handgun in the home. That's the core of the Second Amendment, and anything other than that is not core, and therefore they can balance it away with balancing tests. And again, that is what the anti-gunners want the Supreme Court to do. I don't think it's going to get there. You see, because everything else, according to the anti-gunners, that touches on the Second Amendment rights, other than guns in the home, they view as not a core right, not an essential right under the Second Amendment. And again, that's because a gun control law does not impact a core right. In their view, it's acceptable for courts to use balancing tests such as the tiers of scrutiny as a way to balance away your right to keep and bear arms. Now, as to how courts conclude that the Second Amendment has a core and non-core rights is beyond me. It's absurd, because in reality, it's just an excuse for the anti-gun courts to ignore Heller's rationale. Now, if you like gun rights, here is the likely good news. It is my guess that the Supreme Court in Bruen will apply and re-embrace the text, history, and tradition test, and will once again reject any sort of balancing test. Now, here's why I say this. First, during the oral argument in Bruen, even New York's attorneys seemed to agree with the Supreme Court's questions at argument that the Heller framework of text, history, and tradition was the proper criteria for deciding Second Amendment cases. And as Justice Antonin Scalia, the late Antonin Scalia, wrote in Heller, quote, "The very enumeration of the right takes out of the hands of government, even the third branch of government, which of course is the courts, the power to decide on a case-by-case basis whether a right is really worth insisting upon." So I think based on that language of Heller and New York's concession, text, history, and tradition will be the criteria that Supreme Court embraces for Second Amendment cases, which is really, really good for gun owners. Second, Chief Justice John Roberts, who I would say is kind of in the middle of the current court. He's considered the swing vote right now. He has already stated on the record that he does not think that balancing tests such as tiers of scrutiny analysis is appropriate for Second Amendment cases. In fact, what John Roberts said during the Heller oral argument is that he actually labeled tiers of scrutiny as a barnacle on the constitutional law that got stuck there thanks to earlier liberal activists on the courts. Okay? So it seems unlikely that John Roberts will apply text and tradition to the Second Amendment right to keep, but not to bear arms. And lastly, if you look at the decisions of Justice Brett Kavanaugh and Justice Amy Coney Barrett when they were on the lower court, if you take a look at those decisions, they both believe that Heller requires that Second Amendment cases be decided by the text, history, and tradition approach. You see, in Heller 2 in 2011, Judge Kavanaugh, now Justice Kavanaugh, basically embraced all this. If you want to read a great decision explaining the meaning of Heller and what text, history, and tradition means, then the Kavanaugh dissent in Heller 2 is very powerful. I should also mention that in 2019, in a case called Cantor versus Barr, then Judge Amy Coney Barrett dissented applying history in deciding whether Mr. Cantor had a basis to get his gun rights back after he was convicted years earlier of a nonviolent felony. Again, I think this shows that there are 5 votes on the Supreme Court at least to apply the text, history, and tradition test and to reject the intermediate scrutiny test that the anti-gunners want the court to apply. So let's talk about how I think the court is going to apply the text, the history, and the tradition test that the question presented in Bruen. You see, I suspect that what will happen is that the court will read the text of the Second Amendment and will note that you really are talking about 2 rights, i.e. the right to keep arms, which is the right to possess, and that was acknowledged in Heller, and also the right to bear arms, which means, of course, the right to carry them. I think the text itself is going to get the Supreme Court pretty far down the line to decide that we have a right to carry guns in public as a fundamental constitutional right. You see, the right to keep means the right to have a gun in your home, but the right to bear means more than carrying guns from your bathroom to your bedroom to your living room, of course. It means, of course, To bear means to have a gun and carry it outside in public. But let's go beyond the text of the Second Amendment. I think the text answers the question, but let's go beyond the text of the Second Amendment and actually look at how the court, I think, is going to look at the history during the founding period, which will include the year the Second Amendment was prepared and ratified, the year 1791. The Supreme Court, I suspect, is going to look at some of the founding era history, which I generally consider the time period to be 1760 through July 4th, 1826. Now, the reason why I say that July 4th, 1826 ends the founding period is because that is the date on which John Adams and Thomas Jefferson both died, believe it or not, on the 50th anniversary of the signing of the Declaration of Independence. Okay, and the historical record during that founding era demonstrates that Americans were allowed and did in fact carry firearms. The evidence that they did so is simply overwhelming. I'm just going to give you a handful of illustrations that I think the Supreme Court will use in their ultimate Bruen opinion. And many of these examples, by the way, if you watch this channel, you may have seen this in other videos that I've done. But I put it all together here in that speech, and I'm giving it to you again right here and right now. First, I think one of the biggest factual hurdles that the anti-gunners cannot overcome is that the first eight presidents of the United States regularly carried firearms outside of the home. That's right, each of them, George Washington, John Adams, Thomas Jefferson, James Madison, James Monroe, John Quincy Adams, Andrew Jackson, and Martin Van Buren all carried firearms outside of the home. To begin with, the father of our country, George Washington, himself regularly carried a gun for hunting and advised his grandson to do the same. John Adams, the attorney for the British officers in the Boston Massacre trial, and of course, one of our founding fathers and one of our early presidents, was so fond of shooting guns that John Adams would actually take his gun to school and would go shooting and hunting after his studies. Thomas Jefferson, who penned the Declaration of Independence itself, carried pistols for self-defense when traveling, and Thomas Jefferson even designed a special wooden holster to hang on his saddle for which he could handily take his guns in and out. He actually encouraged, by the way, his nephew to let your gun be your constant companion. That was Thomas Jefferson's advice to his own nephew. Let your gun be your constant companion. Our fourth president, James Madison, bragged that his aim was so good that he rarely missed a shot at 100 yards. Probably he would have a gun trick shot channel on YouTube if James Madison were alive today. Our fifth president, James Monroe, traveled to school with his musket slung across his back. And as an adult, Monroe kept pistols in his carriage wherever he traveled. John Quincy Adams, the son of John Adams and the attorney for the enslaved Africans in the famous Amistad case, John Quincy Adams loved to hunt and repeatedly wrote in his diary about how he went out with a gun. Andrew Jackson, our seventh president, famously said, quote, "I've never in my life seen a Kentuckian who did not have a gun, a pack of cards, and a jug of whiskey." And Andrew Jackson's actions reflected this point. We know this from Jackson's biographer and prominent historian H.W. Brands, because he said that Andrew Jackson, quote, "For arms he carried a pair of pistols in saddle holsters, a pistol worn in his belt, and a new rifle." That, by the way, is 4 guns that Andrew Jackson was carrying, if you are not counting. And finally, last but not least, Martin Van Buren, our eighth president, was reported to carry 2 loaded pistols with him whenever, for example, he visited the United States Senate to ensure that discussions stayed civil and tempers remained checked. Now, in light of this history and the arguments made by New York that you could not carry in public, this would keep this in mind. I want to think about this. Now, New York's argument in Bruen is basically this, right? That you were not allowed to carry guns in public. That was their argument at the time of the founding. Believe it or not, that's what they argue. So what this means, of course, is the first 8 presidents of the United States would have been habitual criminals carrying guns in public illegally, if you believe what the anti-gunners are arguing to the Supreme Court. That is that you could not carry guns in public at the time of our founding, which I think is just historically not true. And if it were true, then it means that all the presidents of the United States, the first 8, were criminals at the time of the founding. I find that to be, shall we say, a stretch. I think the second point the Supreme Court will emphasize in a decision in Bruen saying that you have a right to carry guns is an early founding legal history dealing with the right to carry, as explained by none other than a future president himself. That would be Attorney John Adams. You see, in the famous Boston Massacre trial of 1770, future United States President John Adams defended the British soldiers who were charged with murdering American colonists in downtown Boston, Massachusetts. Now, some of these colonists were armed with clubs. It's undenied. It's in the trial record at the time. And John Adams was an expert lawyer, probably the best lawyer, certainly in Massachusetts, maybe even the country, a major lawyer he was. Now, Adams surely would have been smart enough to have seized on any plausible argument that being armed was itself unlawful. That would have bolstered his client's case for acting in self-defense, obviously. But Adams did not make this argument. In fact, at trial, he conceded the following point, quote, "Here, every private person is authorized to arm himself, and on the strength of this authority, I do not deny the inhabitants had a right to arm themselves at that time for their defense, not for offense." The other thing I think the Supreme Court is going to mention in their decision finding that we have a right to carry guns in public outside of the home is if you look at the purposes identified by Heller in 2008 about why we have a Second Amendment. Okay, why do we have a Second Amendment and why do we have the right to self-defense? Well, obviously, much of this takes place outside of the home in public. Think about it. Hunting takes place outside. Fighting tyranny takes place outside. Lexington and Concord, the start of the American Revolution, where was that? That was a battle outdoors in a public green, right? This is a battle against tyranny outdoors by Americans. These are the same Americans that wrote the Constitution. They knew this history. And I think that Justice Kennedy, Anthony Kennedy, the former Supreme Court justice, during an oral argument, Heller summed up the importance of having the right to carry guns in public quite nicely when he asked a lawyer for the District of Columbia the following question. He wanted to know whether the American colonists needed firearms, quote, to defend himself and his family against hostile Indian tribes and outlaws, wolves and bears and grizzlies, close quote. Justice Kennedy asked that question, flagging all those reasons why we have the Second Amendment and a right to have guns outside of the home. Okay. The next thing I think the Supreme Court will mention in its opinion is that you had a right to carry a firearm outside, but in fact, not only did you have a right to carry guns outside, but in fact, many states and colonies actually required you to carry a firearm in public, such as when you went to church. So not only did you have a right to carry a gun, you actually had an obligation to do so. Okay? And I think the next argument will be that we know that there were also state laws that prohibited slaves from carrying guns. Okay, let's think this through for just a second. We know there were state laws that prohibited slaves at the time of the founding from carrying firearms without the written permission of their owners. Now, here's why this is important. These anti-carriage laws would make no sense if nobody in the country, if nobody in the founding period was allowed to carry firearms in a given state, right? They only would make sense if everyone was allowed to carry firearms peaceably except for slaves. That's why those state laws made an exception for slaves, saying that slaves couldn't carry guns without the permission of their owners, because everyone else could carry guns otherwise in public at the time of the founding. So as you can see, I think there are many compelling arguments that the Supreme Court will be able to use to support the right to carry guns outside in public for self-defense under the phrase, the right to bear arms. Again, the right to keep arms is the right to have arms, to possess arms in your home. The right to bear arms means to carry guns for self-defense and other purposes in public. The right to keep and the right to bear arms. Okay. So now in the Bruen case, what does the state of New York argue? And what do its friends argue based on history that you and I don't have a right to have guns in public at all? Okay. The first thing they point to, believe it or not, is something called the Statute of Northampton, which was enacted in the country of England during the year of our Lord 1328. Now note that the statute of Northampton in England was created over 200 years before the birth of a man named William Shakespeare. So it's a very, very old law. Now, before you immediately say, Mark, we don't care about English law, it's actually not that easy to say, because here's why. It is true that several American colonies, including Virginia, Massachusetts, and some others, had analogs to the Statute of Northampton at the time of the adoption of the Second Amendment. However, there's an excellent scholar that I've talked about on this channel named Stephen Halbrook, who's debunked this argument in his great book from 2021 called The Right to Bear Arms. I strongly encourage you to pick up a copy if you're interested in the history of the Second Amendment. It's very powerful. Okay, now the Statute of Northampton and its American analogs was understood, and Stephen Halbrook explains this in detail in his book, it was understood to mean that you could not go forth and use firearms to the terror of the people. It was really an anti-terrorism statute or an anti-threatening statute, as opposed to just you couldn't carry guns peaceably statute. All right, there was a discussion of this case called Sir John Knight's case that was actually discussed, I think, during the oral argument itself by the Supreme Court in Bruen. And in that case, it involved a knight, an actual knight, who was charged for violating the Statute of Northampton, but Sir John Knight was acquitted because the jury found that while he did carry arms, he did so for peaceable self-defense and not to terrorize or stalk or threaten the people. And again, remember the following, that Virginia and Massachusetts were two of the states that had these Statute of Northampton analogs, but Virginia and Massachusetts were where the first 6 presidents of the United States came from, right? Including Thomas Jefferson. And again, I go back to my point that if the anti-gunner argument is true, that people could not carry guns in public lawfully in the founding period, then the first 8 presidents of the United States, including those from Virginia and Massachusetts, would all be criminals. And that's simply absurd. I don't think the Supreme Court would conclude that. And again, the reality is this, that the Statute of Northampton was really an anti-terrorism statute that says you couldn't take guns out and use them to disrupt the peace or scare people or intimidate people or terrorize people, but it had nothing to do with just peacefully carrying guns for self-defense. The second historical argument that the anti-gunners make, or that New York makes before the Supreme Court as to why you're not allowed to have a gun outside the home in self-defense, is based on a Massachusetts law from 1836. This was a so-called surety law or a bond law, which, as you know, a surety means just posting a bond. Now, this surety law in Massachusetts was enacted in 1836, which again is 10 years after the death of John Adams and Thomas Jefferson. So 1836 is really not in the founding period, which is when the Supreme Court looks to understand what did the Second Amendment mean by the people who adopted it in the year 1791. 1836 is after that period, and thus really should not be relevant to what the Supreme Court has to decide about the meaning of the text of the Second Amendment. Okay. Moreover, the enactment of this law, which again is sometimes called the Massachusetts model of gun carriage. If you're an anti-gunner, this is the sort of thing you would talk about, the Massachusetts model of gun carriage. Really, if you think about it, the argument blows up in New York's face, because you got to think about the two things together. On the one hand, New York is kind of arguing that the Statute of Northampton said that nobody was allowed to carry guns in public during the founding, right? That's what the Statute of Northampton, the American analog, said you could not carry a gun in public at the time of the founding. Okay, so let's think about this. If the Statute of Northampton and its American analogs were really carriage bans, I mean, you couldn't carry a gun in public, then why would the state of Massachusetts need a surety law? Because Massachusetts already had a Statute of Northampton law, right? So, because Massachusetts is one of the states that has Statute of Northampton analog, so why would you need like another gun control law to ban something that's already banned? You wouldn't, especially when I explained to you how this Massachusetts surety law worked. You see, the way it worked was this. If someone in the community identified you you in the Commonwealth of Massachusetts at the time as a menace to society, as a threat to society. You would go to the judge and make a complaint, and then the judge would have a hearing, and then the judge, if the judge found that you were indeed a menace or threat to society, you could still carry a firearm. You could still carry a firearm, provided that you posted a bond, so that if you misused the gun, then you would lose your bond. And that's how it worked. It was not a ban on carriage. Now, think about it, what this really means. That it totally destroys New York's law about history involving the statute of Northampton. Because if no one in Massachusetts was allowed to carry a gun under the statute of Northampton in the state of Massachusetts, then who would be allowed to carry guns under this surety law? Only people who were found by a court to be a threat to society. That cannot possibly be a conclusion that the Supreme Court can draw that makes any sense. And I don't think the Supreme Court will draw such an absurd conclusion. But again, it just shows you how far the anti-gunners are stretching American history to try to deny us the right to carry guns in public. Now, New York's third historical point is that there were bans on concealed carry in the early 19th century. And this is the thing, guys. They're correct about this historically. In the early 19th century, in some states in the South, there were, in fact, gun carriage bans banning concealed carry. This is key. Banning concealed carry. But there were litigations over this, and the opinions that upheld these concealed carry bans did so, but why? These court opinions that upheld the concealed carry bans in the South in the early 19th century did so because the states permitted the open carriage of firearms. They allowed you to openly carry firearms in the early 19th century in these states. And therefore the court said, since you're allowed to openly carry guns, you can use guns for self-defense, we can ban you from carrying guns concealed because you can still carry them open. But remember, New York State today, you're not legally allowed to carry a gun openly. Your only option is to carry concealed. So those early 19th century laws that the anti-gunners like to point to that allowed concealed carry bans to stand, they conveniently ignore the fact that those states allowed people at the same time to carry their guns openly for self-defense. Now, the fourth historical argument that New York points to is what I call the Wild West argument. Okay, now, what they're really saying is that there were some cowpoke Wild West towns that supposedly banned the right to carry guns. Some of this is somewhat debatable, but really at the end of the day, it doesn't matter. Because these laws in places like Tombstone, Arizona, or Salina, Kansas, they all supposedly, again, restricted the right to public carry of handguns. But I don't think we should be taking guidance from these old West towns. And I don't think the Supreme Court's really going to care about a handful of territories and cities in the late 19th century dealing with cowboys and cowpokes, okay? And here's why I think the Supreme Court's going to blow these laws off. First, the laws in these cowpoke towns were enacted just too late in the day to shed any light on what the Second Amendment means in 1791 when the Second Amendment was adopted. You see, the second problem with relying on these Western laws is also there are just a handful of these out there. They're needles in the legal haystack, which one federal judge said in 2016, over a teeny percentage of the American population. And I actually think several of these jurisdictions weren't even states. I think they were actually territories in the late 19th century. So again, even more of a reason to kind of disregard them if you're the Supreme Court. And furthermore, while a few of these Western jurisdictions may have had broad bans on carrying guns on the books, it's not clear that we have a lot of evidence, if any, about how often these laws were actually enforced. I mean, just because a law is on the book doesn't mean that should enforce our understanding of constitutional rights, especially if it's never enforced or rarely enforced. And again, don't forget, to the extent any cowboy was convicted under these anti-carriage laws, if that were to occur, how many of these poor cowboys would have had the money to hire lawyers and the time to litigate these cases before the next day's cattle drive. How many civil rights lawyers would be coming in from New York City into these dusty towns to assert Second Amendment rights or any constitutional rights whatsoever? And the answer is none. There's none. None of this would have been happening. And of course, it's very unclear that in the late 19th century, did the Second Amendment even apply to state and local governments, because there's so few gun control laws, there weren't really a lot of litigations at the time, and the doctrine of incorporation for those lawyers out there hadn't really, come about and did not exist. So and again, at the end of the day, the vast majority of the states in the late 19th century in the United States protected the right to carry at that time. So again, no real need for major litigations about the Second Amendment in the late 19th century, because it just never came up. The fifth argument that New York really argues about why you and I don't have a right to carry guns is specific to rural versus city, believe it or not. What they try to argue is to say that New York has some really densely populated areas like New York City, Rochester, Buffalo, Albany. These are densely populated areas, so they say. But again, this idea that you can distinguish between constitutional rights being recognized in like a city versus in a rural area of America makes no sense. Because if you're an American in the United States, you have certain constitutional rights. And they don't vary depending on where you happen to be at a given moment in time, right? Your right to free speech is as effective in New York City as it is in like rural Montana, okay? And again, let's not forget what Attorney John Adams argued in the Boston Massacre trial in Boston, arguably the largest city at the time of the founding, or certainly one of the largest cities at the time of the founding, Boston. He argued that the colonists in Boston had the right to have arms in public in the most populous, busy, largest city at the time of the founding. So any suggestion by New York that you have a right to restrict gun rights in cities because they're densely populated simply does not fly. In fact, I think Chief Justice John Roberts, in the oral argument in the Bruen case, actually understood the absurdity of this position that New York was trying to advance when he made kind of a joking question to the New York attorney making the argument. And what John Roberts asked her, like, well, how many muggings take place in the forest? And that was from John Roberts. And of course, we know what he was suggesting, which is often the need for guns in public for self-defense is greater in the cities than it is in rural parts of this country. I want to issue a major warning here. This is, I think, the greatest danger to gun owners in the Bruen decision. There was a lot of discussion at oral argument about gun-free zones or sensitive places, because in the Heller case in 2008, there's a reference there that says nothing about the Heller decision suggests that you have a right to carry a gun in sensitive places such as government buildings or schools. That was kind of a passing reference in what's known as dicta, which is not the central holding, but it was a passing reference there. And what's happened is, since then, a lot of liberal courts and liberal anti-gunners and legislatures have embraced this idea of sensitive places as a way to restrict where you can bring a gun. So even if you have the right to carry guns in public, they restrict where you can bring the gun, claiming all sorts of places are sensitive places. For example, right now as we speak, I believe the state of New York, in anticipating losing the Bruen case, is already talking about how to define sensitive places quite broadly, so that even if New Yorkers have the right to carry a gun, they're going to be limited as to where they can carry that gun, because they're going to, the state, I suspect, is going to try to define everything in the state as best they can as a sensitive place. So this gun-free zone sensitive place exception is a very big danger, and we have to watch this very carefully. Now, the right answer is under the text, history, and tradition approach to the Second Amendment. There's really like maybe three areas, I would say, where you could constitutionally make a gun-free zone. I think under the text, history, and tradition of the Second Amendment and the founding era, first area is I think you can ban guns in courthouses. That was the case because you had bailiffs with weapons to protect you. Likewise, I think they could ban guns probably in government buildings, again, where they have armed officers there to protect you, where the government has basically taken over the responsibility to use force to protect the lives of the people in that building. Think about TSA for a moment. TSA is an example where when you go through those metal detectors, you're not allowed to have a gun, but they have, people with guns and weapons there to protect you. They're basically taking on that responsibility. So I suspect where the government is saying, we're going to take on the responsibility for protecting your lives, well, then maybe they can declare that a sensitive place. But I think actions are going to have to speak louder than words. I don't think at the end of the day, a state just labeling something a sensitive place is going to be sufficient. So for example, in the state of Virginia, I believe, there are people there that have declared, I think one of the counties has declared like 20,000 acres of public park a sensitive place, and that's being litigated right now. Clearly that's not a sensitive place, but that's what the government is trying to do down there in Virginia. There are two additional arguments I want to bring to your attention that New York and the Friends of New York are arguing to take away your right to carry guns in public before the Supreme Court in the Bruen case. The first is what I call waving the bloody shirt argument. They're basically just saying that if you require us to give people the right to carry handguns in public, even if they're law-abiding citizens who meet objective criteria, like they're not convicted felons, this is going to harm public safety, okay? The second thing that some supporters of New York are arguing is a doctrine that we've talked about on this channel called Corpus Linguistics. Corpus Linguistics, or Corpus Linguistics analysis. And they say that under Corpus Linguistics analysis, the Second Amendment's text does not protect an individual right to carry guns in public. Neither argument, in my view, works for New York, and here's why. Let's start with the public safety argument, okay? It's a typical anti-gun argument that guns carried in public create a net cost in terms of public safety. Does this argument have merit? The answer is, of course it doesn't. Again, we should not even be bothering to argue about public safety implications of the Second Amendment when it comes to what is the meaning of the Second Amendment. And why is that? It's because the Supreme Court's ruling in Heller clearly established that the constitutionality of a gun control law turns on the text, the history, and the tradition of the Second Amendment, not on any social science-driven balancing test, which again are terrible for gun rights, okay? Mostly because of who's applying the rules, meaning anti-gun judges, okay? So based on what the court said in Heller, this part of my speech should be irrelevant, right? Because we also know from the Supreme Court's decision in McDonald in 2010 that other constitutional rights have public safety implications, meaning that they allow criminals to go free, for example. Let's look at the criminal procedural rights in the Fourth Amendment. Under the Fourth Amendment's right to search and seizure, if the police screw up, they get evidence they're not allowed to have, they get struck. And guess what? Some criminals get to go back out on the streets and commit more crimes. Public safety implication, but we honor the Fourth Amendment because that's how America works. The First Amendment, actually allows you, according to Supreme Court precedent, to argue for the violent overthrow of the government. Look at the Brandenburg versus Ohio case from 1969. And yet again, we recognize the First Amendment because again, it's how you interpret constitutional rights. The Bill of Rights protects them, even if there's public policy implications or public safety implications that may be negative. But let's, for the sake of argument, believe or assume that New York's lawyers can convince 5 or more justices to accept public safety as being relevant to constitutional analysis. Does New York's public safety argument actually work? Do we have clear evidence that more frequently allowing at least Americans to public carry handguns is going to somehow increase the violent crime rate? Again, the answer is undeniably no. In fact, it turns out that preventing people from carrying guns in self-defense actually would harm public safety more than because it would prevent effective self-defense against criminals. This is a bit of wisdom that America's founding fathers understood. And one thinker that I've written about somewhat extensively and talked about on this channel, who deeply influenced the founding fathers, was the 18th century Italian criminologist by the name of Cesare Beccaria. Cesare Beccaria. In a passage that Thomas Jefferson himself copied into his personal legal commonplace book, Beccaria said that laws which forbid the wearing of arms end up disarming only those who are not disposed to commit the crime which the laws mean to prevent. Restrictive gun laws, Beccaria added, do not prevent murder, but rather actually encourage murder, as it requires less courage for criminals to attack unarmed rather than armed persons. Beccaria likened banning guns to depriving people of fire for fear of being burnt, or depriving them of water for fear of being drowned in water. Now, of course, we all know that the great and the good among us all know that guns save lives by stopping bad people from doing bad things to good people. And why do I say that? It's because they all carry guns or hire people who carry guns to protect them. Hollywood celebrities, rich anti-gun donors, and of course, anti-gunners now living in the White House all benefit from armed protection. Ask yourself this: why does the Secret Service carry guns in order to protect the President and the Vice President of the United States? What's the point of the guns? I mean, isn't it interesting that President Biden thinks that so-called gun violence is an epidemic when you own guns and when I own guns? But the last time I checked, Joe Biden was not ordering the disarming of any of his Secret Service agents. Why not, Mr. President? Maybe you should go first and give up your guns, Mr. President, before you ask us to give up ours. Now, we know why elites hire armed bodyguards, because armed self-defense works. For example, in 2020 alone, Facebook's Mark Zuckerberg spent $23 million on private security. Do we think that included maybe a few guns in that price? I suspect the answer is yes, it did. Remember, and we've also talked about this on this channel, there was a major 2021 study by Professor Bill English of Georgetown University. In this study, Professor English estimates that there's approximately 1.67 million uses, defensive uses of guns for self-defense every year. Think about this. That's 16 million defensive gun uses in any one decade. Now, this also breaks down to 32,000 cases of armed self-defense each week, and more than 4,500 cases of armed self-defense every day in the United States. Now, what's interesting is that each case represents an instance when a person had the means to prevent harm or loss of life because he or she was armed. Now, I want to mention one thing that's very much important worth noting here. That is, according to Professor English's study, most of these defensive gun uses did not require the threatened individual, the threatened victim, to even fire a single shot, because just brandishing the gun or stating that they had the gun was sufficient to deter the threat and save a life. Now, let's think about this question a bit differently. Which of these signs, this is a common sense question, folks, which of these signs do you think would be more effective in preventing another mass shooting? A sign that states, notice, gun-free zone, no weapons allowed. Or a sign that states something like, warning, staff and occupants are fully armed and are able to shoot if needed. Now, there's a reason why mass killers, in my opinion, do not target police departments. It's not the blue uniforms that deter, but it's the guns in the police's possession. So it seems to me clear that by allowing Americans to freely carry firearms in public improves public safety by allowing effective self-defense against bad people who want to do bad things to good people. Now, beyond the obvious fact that carrying guns saves lives, which is why all the rich elites, including political elites, get armed protection because the arms protect lives, right? I think New York and their friends in the Bruen case cannot prove with evidence, at least persuasive evidence, that restricting public carrying of firearms in any respect helps public safety. I mean, social scientists have been studying whether more guns in a state causes more crimes. And the evidence, as I have been able to interpret it, is overwhelming that laws allowing law-abiding adult citizens to obtain a license to carry firearms in public does not increase crime. Now, I don't want to dwell on boring statistics, but I think there's two observations I want to make about this. The first is, if you take a look at some of the studies conducted by those organizations that I consider, in my opinion, establishment organizations, maybe even left-leaning organizations, who have looked at violent crime rates and public carry laws, and guess what? Their conclusions do not help New York's argument that preventing people from carrying guns somehow helps save lives or improve crime statistics. In fact, recently, the RAND Corporation, very prestigious organization, the RAND Corporation, conducted a comprehensive survey evaluating what it called an explosion in research on the subject of carry laws since the late 1990s. Now, the RAND organization's report, the RAND Corporation's report, found that the evidence that right to carry laws either increase or decrease crime is just inconclusive, which is really code for we couldn't prove that guns cause a net increase in crime, so we're just going to say it's inconclusive. Now, I would not consider, in my opinion, the RAND Corporation to be any kind of major supporter of the Second Amendment. But again, that's just my view. But if they're coming out saying, we don't see evidence that banning public carry helps public safety, that's pretty damning evidence from the point of view that New York is making, which is banning public carry somehow saves lives and improves crime rates or whatever, okay? But let's just skip the statistics for a moment. And why don't we just look at the lived experiences of those millions of Americans, as well as the dozens of states over the last several decades that have embraced concealed carry laws across the country. You see, during this few decades, we've seen a tsunami of laws eliminating restrictions and obstacles to public carrying of handguns. Since 1975, 36 states or more at this point have made their carry laws less restrictive. And during the same period, the violent crime rate is, guess what? It's gone down. It's plummeted. Now, by the way, this point has not been lost on the U.S. Supreme Court. During oral argument in Bruen, Justice Kavanaugh actually made this observation, okay? Here's what Justice Kavanaugh said. He says, there really isn't any real evidence that the 43 states that have shall issue or constitutional carry regimes have a lot more accidents or crime. That was Justice Kavanaugh noticed that and mentioned it during oral argument just this past November. And finally, of course, let's ask yourself this way. If allowing law-abiding citizens to carry firearms in public is such a threat to public safety, I mean, it gave rise to blood running in the streets, why have so many states that have made their carry laws less restrictive continue to maintain those laws as less restrictive, or made them even less restrictive? Right? Why have 0 states repealed their switch to shall issue laws? And why have 0 states repealed their switch to permitless carry? Why is it a one-way ratchet toward more gun freedom and not less gun freedom on the gun rights issue? Well, I think it's quite simple, because the actual experience of Americans proves that guns save lives, and Americans act responsibly with firearms, okay, which is the American way. Simply put, I think New York's assertion and New York's friends' assertions before the Supreme Court that there will be some sort of bloodbath in the street if you allow the more carrying of firearms in public has simply not been borne out by the American experience. Now I want to turn to another argument advanced by some of New York's friends in their amicus briefs to the Supreme Court in the Bruen case, arguing in favor of more restrictions or outright bans on the right to carry. Now, these arguments are based in a doctrine or theory called Corpus Linguistics. Corpus Linguistics, okay? And I just want to spend like 2 minutes on this because neither New York nor the justices at oral argument seem very interested in the topic of corpus linguistics. But you see, there's a lot written about this topic in the literature, and several amicus briefs mention corpus linguistics, so I want to point out its flaws as I see it as a tool for interpreting the Second Amendment. First of all, as I see it, corpus linguistics is really nothing more than a fancy way of describing a glorified Google search of certain historical databases, okay? It's all it is, a Boolean search of words. the way it works is a researcher takes an electronic database consisting of documents from, let's say, the founding period. Could be any period, but let's say the founding period. And then they do a bunch of computer searches for keywords and key phrases as they see it. Then what they do is they review search results and they try to figure out how many times a particular word, such as the word arms from Second Amendment arms, was used in a specific context, and then they sort of count it out. Now let me give you like an example how this works. Let's say you were trying to understand what does the word airplane mean in the 1940s in the United States? What does the word airplane mean in the early 1940s in the United States? Let's assume that's your research question. Well, of course, you could pick databases of historical materials from the 1940s, and you would run searches of the use of the word airplane or plane. Once you got back the results, guess what would happen? You would find out that in most of the instances in, let's say, the newspapers from the early 1940s that refer to airplane meant a military vehicle and not a civilian plane. And what I mean by that is, let's say you're trying to figure out whether or not airplane meant in the early 1940s a military vehicle or a civilian vehicle. Well, the way the Corpus Linguistics people would argue, I believe, is they would say you do the research in that time period of the early 1940s, you would then look at the context in which the words airplane appeared, and you would just count them up. How many times was the word airplane used in the context of a military vehicle? And how many times was the word airplane used in the context of a civilian vehicle? And whichever number is greater, we interpret the word airplane to mean that. And of course, because in the early 1940s, which is why I picked this as the illustration period, in the early 1940s, guess what? Most of the references about airplanes would be in the context of World War II. So in that one time period, the reference to airplane would be mostly in the context of military uses. But that means that if you counted it up, most of the references would be airplane means military vehicle. But we all know that's not true, right? Because an airplane can be used for the military, but it can also be used for civilian purposes. So just because in a certain time period, it's often used in the military or more often used in the military, doesn't mean that that's the proper definition. Now, why do I bring this example to your attention? It's because this explains how, as I see it, the Corpus Linguistics people are arguing why you and I don't have the right to carry guns based on their Corpus Linguistics analysis of the founding period. Because what some of these Corpus Linguistics experts have attempted to do is they go back in time and they look at the founding period and say the phrase to bear arms, which is found in the Second Amendment, to bear arms, is found in the Second Amendment during the founding period. Guess what? When they do their analysis of the databases in the founding era and they count up how many times is to bear arms used in like the military context versus the civilian context, guess what they conclude? They conclude that there are more references to bearing arms in the military context than in the non-military civilian context, and therefore they conclude that the text and the history of the Second Amendment and what to bear arms means is actually using guns in the military context for government military, for the army, for the militia, has nothing to do with Mark or you carrying the guns privately. That's at least the basis of their argument. Of course, my thought is that's clearly not true because it's far too simplistic of a way because you fail to look at the context. Because remember, during the time of the founding period, you had a massive amount of military issues that were appearing in the local newspapers of the day, right? Think about it. You had the American Revolution, a war. You had the French and Indian War, another war, okay? So, and then you had a massive legal discussion about what is in the Constitution, what should not be in the Constitution. And a big part of that debate was, should we as a country have a standing army or not? Or militia? So you have all this sort of historical stuff causing the debates and the discussions in the papers that are being researched by the Corpus Linguistics people. And guess what? They conclude, needless to say, that it's mostly military. But again, that doesn't tell us anything about what the meaning of the Second Amendment really means. Another point I want to make about why Corpus Linguistics, I think, doesn't tell us what the Second Amendment means and why it fails is because the documents in the databases that are being searched by the people who do Corpus Linguistics, again, the documents in the databases that are being searched by the people that do Corpus Linguistics have been known for centuries, okay? We're not talking about a situation where there's documents to be uncovered in an attic that James Madison wrote about the Second Amendment. That's not what we're talking about here. What we're talking about here is documents that have been put in a database, documents that people have known about for hundreds of years and have been written on by historians, such as Second Amendment historian Stephen Halbrook and others. They've already analyzed these things, and now all they're doing is taking the exact same documents that have been understood and known about by historians for centuries. They throw it into a single database, and then they try to do this word count. And I don't think it really works at the end of the day. And by the way, I want to say one thing, that the U.S. Supreme Court in the Heller case already rejected a similar kind of argument, not called corpus linguistics, but basically an argument made by linguistics, not corpus linguistics, but similar, made by linguists in the Heller case, where they try to argue that linguistically, to the right to keep and bear arms meant malicious service, had nothing to do with private arms, but Justice Scalia dismissed this argument as simply not persuasive. So the Supreme Court has rejected linguistics arguments. I think they will reject these arguments by the corpus linguistics people as well, but you should at least be aware that they're out there and how it works. I want to finish up this presentation about where the Second Amendment stands in the courts today by talking about what I consider to be the next frontiers of Second Amendment litigation after the Bruen decision is decided in likely June of 2022. Of course, it's not knowable until we see what the opinion says, how broad it is, how narrow it is. So it's hard to know what dicta or holding will be in there. So it's hard to know exactly what litigation will come after Bruen, but I think there's some things we can assume are going to be big fights. I think the major big fight that we're going to see after the Bruen case is decided is how broad is the sensitive places gun-free zone exception to the right to carry. I think this is a big issue because I think the anti-gunners know that they're going to lose the right to carry guns, that the right to bear arms means you have the right to carry guns in public, and I think the anti-gunners are going to desperately try to define as much of the country as a sensitive place, gun-free zone as possible. And the question is, to what degree will the Supreme Court preempt some of this stuff and head it off at the pass and say you can't do that? Again, if you look at some of the amicus briefs that were filed in the Bruen case, what you really see is that at the founding period, there were a few sensitive places where you could ban guns. They were really the courts, because you had bailiffs with guns, polling places where people were voting, and then students, but not teachers. Students at schools were not permitted to carry in some instances, mostly because I think people feared that the students would engage in dueling. But I should note that the professors and the teachers and the adults were allowed to carry on campus. It's just the students were not allowed to at places like the University of Virginia, where Thomas Jefferson and James Madison were both on the board and were aware of this, presumably. Again, it does not apply to teachers. And I think at the end of the day, you have to keep in mind that this is really a metaphor or analogy to the TSA, or Transportation Security Administration. Once you go through some form of screening, the government has then devoted enough resources that you don't need to worry about your self-defense with the firearm, because somebody else, whether it be TSA or someone else, has actually got guns right there to protect you from bad people. So you don't need to worry about doing it yourself, okay? I think the next thing we have to worry about in the sensitive place fight is buffer zones. Now you may, if you're a constitutional lawyer, you probably are familiar with the concept of buffer zones dealing with abortion laws, where you sometimes have cases that talk about protesters have to stay away from property where there's an abortion clinic and there's a buffer zone just around the clinic, and whether or not that violates the First Amendment, free speech and all that, we don't need to get into that here, but just be aware that you got to be careful about buffer zones extending the right of sensitive places. Because, for example, right now in the District of Columbia, there is buffer zones relating to motorcades. So you have a concealed carry license in DC, but you're not allowed to be within 1,000 feet, I believe, of a motorcade with a VIP. But the problem is, how do you know where the motorcade is going to be at any given time? You know, you're walking down the street with a gun and some, VIP motorcade with the president goes zipping by you. What are you supposed to do? Like sprint away, run away? I don't even know how that works. But again, that is the reality of what they're trying to do. And I think what the anti-gunners will try to do is to expand sensitive places. Okay, I think the other areas where you're going to see fights over the Second Amendment, the next cases at least, will be probably whether or not bans on AR-15s and AK-47s or so-called assault weapons, whether or not they're constitutional. And I think with respect to these modern sporting rifles or AR-15 platform guns, Heller has the relevant test. And the relevant test in Heller is an arm is protected under the Second Amendment if the firearm is commonly possessed by law-abiding citizens for lawful purposes. If it is commonly possessed by law-abiding citizens for common purposes or lawful purposes, it's protected. And under any understanding of the term common, AR-15 should meet the test. They are the most popular rifle in America. There's at least 10 million of them in private ownership, and they're used in only a tiny percentage of the crime. 99.9% of these AR-15 style guns will not be used in any criminal activity whatsoever. And don't forget, I mentioned here earlier, the Caetano versus Massachusetts case that said that stun guns were protected arms. Bear in mind that stun guns did not get invented and get really implemented into American life until the 1970s. AR-15s have been around much longer than that. Semi-automatic rifles much longer than stun guns. And there's certainly a lot more AR-15s out there than there are stun guns today in private possession, okay? The next area of fights will be magazine limitations, large capacity magazines, which are really just standard capacity magazines or commonly possessed magazines. Again, there are petitions before the court right now seeking cert on these types of cases. The reality is, again, under the commonly possessed by law-abiding citizens for lawful purposes test of Heller, they should be completely protected because, as we know, there's about 150 million of these magazines in private owners, private stock right now that contain 15 rounds or more. So under any conception of the word common, these magazines are commonly possessed for lawful purposes by law-abiding Americans. And again, 99.99% of these won't be, have anything to do with criminal purposes, yet again proving that Americans are law-abiding when it comes to guns, except, of course, with criminals who have engaged in the career of criminality. The next area where I think you'll see some Second Amendment litigation deals with taxes. If you look at Cook County, Illinois, there's been ongoing litigation up and down the Illinois state court system here about whether or not gun taxes and ammunition taxes are constitutional out there. To begin with, we know that poll taxes on voting are illegal. And remember, in 1984, the U.S. Supreme Court, in a case called Minneapolis Star, made it clear that government cannot impose taxes that target the exercise of a fundamental constitutional right. Now, you can't tax something if it just, as a part of a general tax. But if you target a constitutional right, which I think these gun and ammo taxes are targeted, then guess what? It should be illegal and unconstitutional. And in the Minneapolis Star case, which dealt with ink purchased by newspapers that didn't print in newspapers, which is a First Amendment right, the U.S. Supreme Court invalidated it under the First Amendment. And I think gun taxes and ammunition taxes should also be struck down under the Second Amendment on the same basis that you would strike down a poll tax, meaning a fee to pay to vote, or a special tax on ink used by newspapers to print the newspaper, which of course is an expression of First Amendment rights. Another area of litigation you're going to see involving the Second Amendment involves 18 to 20-year-olds and whether they're allowed to possess firearms. The key issue here is whether they are part of the people. Again, the Second Amendment, the right of the people to keep and bear arms, does that apply to 18, 19, and 20-year-olds or just to 21-year-olds and honor and above? The founding era evidence, as I see it, is unequivocal because in 1791, the Second Amendment was enacted, but in 1792, literally months after the Second Amendment was created, in 1792, Congress passed 2 militia acts, and in that legislation, Congress defined 18-year-olds as being part of the militia and required them to keep and bear arms for militia services. So they actually had to own guns and ammunition as part of their life as the age of 18, 19, and 20, among other reasons, so they could show up and participate in the militia. And I think that's powerful historical evidence that young adults in this age cohort have Second Amendment rights. Now, as we speak, there's a case involving this in the 11th Circuit, which touches on Florida, that arose out of a ban on 18 to 20-year-olds being able to buy guns after the Parkland shooting in Florida. And, the 11th Circuit basically is going to hear argument on this, or is hearing argument on this very soon. And we'll see what happens later this year on that case. We know that the Fourth Circuit out of Maryland and Virginia found that a federal handgun purchase ban to be unconstitutional, but this was later vacated as moot because I think the plaintiff had turned 21. But there was a decision there that had found it to be unconstitutional, and that's out there. And the last area of litigation I think we're going to continue to see deals with gun ranges and gun store zoning fights. I think the reason why you're going to continue to see anti-gunners try to go after gun ranges and gun store zoning fights is because they want to destroy gun culture. The last thing the anti-gunners want is for I to be able to talk with you to be able to talk with me at a gun store, at a gun range. They don't want us to be able to communicate even on social media if they could deny us the ability. They don't want other gun owners in America to communicate with other gun owners about our issues because it creates a gun culture in their mind, which we do have a gun culture in America. It's a fact. It's a statement of fact. But they don't like that. And they think that if they make it hard to open up gun ranges, make it hard to have gun stores, make it difficult for people to come together to talk about gun issues in the Second Amendment, they somehow think that that will be strategically and politically helpful to them in trying to make it easier to enact gun control legislation and get gun control judges on the courts going forward. At least that's the goal. So I think there will be ongoing fights about whether or not you can have gun ranges and gun stores in various areas, whether there's environmental risks, all sorts of arguments getting made to try to discourage the people from opening up gun ranges or gun stores. So again, I think this is a pretty good summary of where the Second Amendment stands today, both at the U.S. Supreme Court, where we have been over the last few decades, and where I think the Second Amendment litigations are going to go going forward over the next few years. And I hope you've enjoyed this presentation. And again, this was a speech that I gave about a month ago. And I hope you enjoyed it and learned something. And again, don't forget to subscribe here at the Four Boxes Diner. We'll see you again soon. Thanks for joining us.
Orders up. Table 2A.